Please be seated, everybody. I'm sorry. All right, Mr. Shard, sorry for the delay. Go right ahead, sir.
Well, Your Honor, based on some information that I've learned about today, I'm going to ask if Your Honor would permit me to withdraw the bond motion for the time being, and allow me to refile should circumstances change. There's some things I need to talk to my client about, and I think that would be in the best interest of Mr. Jackson at this moment.
Does he go by Mr. Jackson or Stillwell? Either one.
He goes by Mr. Jackson.
Okay.
But he is also Mr. Stillwell in the indictment.
Okay. All right. Mr. Stillwell, your counsel here is going to withdraw your bond motion for the time being. He'll just talk with you a little bit later, if he hasn't done so already, about about refiling it or potentially taking some other steps. Okay. All right. So, sir, you can be excused at this point in time, sir. I appreciate your patience. Yeah.
Can we arraign him? I'm sorry.
Yes. Mr. Before you go, though, hold on, sir. Mr. Stillwell, hold on. Before you go, Mr. Chart, would you like to otherwise have the court waive formal arraignment, have the court enter a plea of not guilty on behalf of your client, and for you to have at least 60 days from the date of receipt of discovery to file any motions?
All those things are my intention. We do wish. Would you like me to restate them, Judge, for the record? What you just said?
Yes, to weigh in.
We do waive
formal arraignment.
We do waive formal arraignment. We wish to plead not guilty, and we would ask for 60 days, at least 60 days from the receipt of discovery in this case, to file motions.
Granted.
Thank you.
I will go ahead and, as I said earlier, on the 18th of August at 9 a.m., we will have a proffer session and waiver session on the record for the various individuals that we indicated earlier. Okay?
Yes, Your Honor. Thank you.
Okay. All right. And Ms. Charlotte, I will set your client's trial for 9 January of 2023.
Yes, Your Honor.
Okay. All right. I'll give you those. All right, folks, before I go ahead and get started, whatever the decision is today, this is a forum, a public forum, which all are welcome. However, if you feel that you cannot govern your behavior or have acceptable conduct, please, you can exit the courtroom and nobody will be the wiser. If you make any outbursts or statements or anything that the law enforcement professionals in this courtroom deem to be inappropriate, you will be removed from the courtroom and may be subject to other actions. So I just tell you that up front because my deputies are charged with the responsibility of good order and discipline. So whatever my decision is, like it or not, I'll give you an explanation for it, but outbursts were not acceptable, okay? All right. So with that, counsels, I've gone ahead and based upon what has been proffered and the appellate, the case law, I should say, that's been provided to the court, I'll summarize a couple of different things already that you as counsel for the state as well as for the defense, I'm sure aware of. I'm looking at Coleman versus the state, and that's already been cited. That's 361 Georgia Appeals 901. And I'll quote from that decision, which is which comes from our court of appeals. Judge Miller, Miller being the presiding judge in that particular case. Excessive bail is prohibited by the Georgia Constitution, Article 1, Section 1, Paragraph 17, and the 8th Amendment to the United States Constitution. And for the 8th Amendment analysis, as you all are aware, that 8th Amendment violation would be excessive bail or no bail, or fixing an amount that is excessive under the circumstances. When fixing, for the purposes of the 8th Amendment, the excessive bail is defined as bail set at an amount higher than the amount reasonably calculated to ensure the presence of the defendant. When fixing bail in Georgia, trial judges' foremost consideration is the probability the accused, if freed, will appear at trial, and then the court in Coleman goes on to quote that lesser factors or lesser extent or considerations are the accused's ability to pay, the seriousness of the offense, the accused's character and reputation. I have heard a lot of evidence today about those particular factors in regards to Mr. Williams and his ability to pay, and the seriousness of the offenses, and his character and reputation from as presented by Mr. Steele, Ms. Hornsby, as well as Mr. Adams. So I have considered those particular issues. Now, also, Coleman goes on to say that a defendant who seeks release on bail has the burden of showing roots in the community. The defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating witnesses. And along with this particular case, the court also has considered the seminal case of Ayala versus the state at 262 Georgia 704. And Ayala gives us the framework in Georgia for the purpose of a pretrial bond is to prevent punishment before conviction and secure the appearance of a person for trial, quoting Roberts versus the state, 32 Georgia Appeals 339. And it goes on to say that a trial court may release a person on bail if the court finds the following. So I have to look at the first thing that Coleman directs me to look at is consideration of whether or not the foremost consideration is will he, if freed, appear at trial, and then the lesser factors, and these are: a court may release a person on bail if the court finds 1, poses no significant risk of fleeing from the jurisdiction or failing to appear in the court when required. 2, poses no significant threat or danger to any person, to the community, or property in the community. 3, poses no significant risk of committing any felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny bond to assist the appellate court in its review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state, 111 Georgia 307, pinpoint 308, very old case from 1903. Now, in regards to considering bond for Mr. Williams, I have considered the first consideration is if free, will he appear at trial, and to a lesser extent, the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight. And I'll state for the purposes of the record and purposes of my decision that I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to prove to a jury's satisfaction beyond a reasonable doubt, I should say, that he is guilty of the offense or offenses charged. But however, in this particular circumstance, there has been significant proffers about Mr. Williams as being a danger to the community. In particular, the state's proffer that they have taken proffers from other gang members and people who are in this particular indictment and they're not in this indictment, that he is the leader of the gang, he is dangerous, and if he crosses them, he'll kill them or their families. And the predicate or the review of the state, the concerns that I have are some of the statements that he's made about the threats and to others, and that have been chronicled in particular in some of the predicate acts that have been stated for the court's consideration. Whether or not those acts, as Mr. Adams has pointed out, because they have to be proven at trial, is a discussion for another day. But at this point in time, in the aggregate, those particular discussions, in particular, the proffer from the people that the state has talked to already, the group chat that from 2015 starting, anybody goes into a courtroom and tells God honest truth, they'll be fucking killed, pardon me for the language, and this threat is still being talked about. So that is of a concern to the court in regards to the danger to or threats to persons in the community. So and factors poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. That is the court's concern. The two major concerns that this court has is danger to persons and threats to intimidate other witnesses and obstruct the administration of justice. So I have some concerns about the flight that I share with Judge Wolf also indicated, but and I'm not going to hold it against him that he is very successful and has significant means, but those two factors in particular, threats to persons in the community or poses significant risk of intimidation of witnesses, otherwise obstructing administration of justice. The court has considered a number of the predicate statements, and for those reasons in the aggregate, I'm going to deny bond at this time. But Mr. Adams, Ms. Hornsby, and Mr. Steele, certainly if you should file any other additional motions or things change, I certainly will reconsider the court's position on bond. It is not lost on me that I have not given your client a bond, but that is my decision based upon what I have heard, and I certainly appreciate your advocacy on behalf of your client, all of the lawyers thus far who have advocated very well for their clients in this particular position, and I will do my level best to make sure that this case gets tried as expeditiously as possible, and if I can get it on the calendar before the 9th of January, I will endeavor to do so. So, anything else at this point in time?
One thing, Judge.
Yes.
I'm sorry, I know the court sent an email to, I think, the Public Defender's Office concerning getting defendants who are presently unrepresented representation. We wanted to kind of weigh in on that. We filed a motion today requesting the court to respectfully get them so we can get everybody arraigned and get it moved. I want to just give the court...
Mr. Gere, you must think that I have a lot of power. I really don't. But in all seriousness, I've heard from Ms. Bernard, Gina Bernard, and she right now is working on getting people assigned.
I just want the court tells me to bring copies. I'm trying to provide copies. Judge.
Yeah, we certainly, have you given copies to the?
They've been served, yes.
Okay, all right.
Electronically.
Okay, if you'll give those to Mr. Kearns right here, so I think Mr. Chamberlain's gone. But we are the court is inherently sensitive as to that issue, and as soon as those attorneys can be appointed, and I have some correspondence from Ms. Bernard saying that they are working on that issue right now, and that we will certainly get those people brought over as soon as possible. But and if you all have any other information in regards to that, please let us know. But we are tracking that issue, and I will continue to talk and dialogue with Mr. Chamberlain about that. Okay.
Yes, sir. Thank you, sir.
Anything else, folks?
No, sir.
No, sir.
Okay, all right. Thank you for your patience today, folks. Unless you have anything else, we'll be in recess for the time being. Okay? All right, thank you.